want to adjust this too. Yesterday.
All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is Brito versus Salas, number 2024-1184.
Mr. Chief Justice, and may it please the court. My name is Eric Mayer. I represent Petitioner Ashley Brito. The issue before the court is one of statutory interpretation. Whether the word donor, as used in section 742.14, means a person whose biological materials are used to conceive a child through assisted reproductive technology, as that phrase is defined in chapter 742, or whether the word donor has a broader meaning that extends beyond the scope of assisted reproductive technology and would encompass a man who provides the semen used to conceive a child through artificial insemination. The second district below did not critically examine the definition or the meaning of the word donor with reference to its statutory textual context or the canons of interpretation that are relevant. Instead, the second district intuitively assumed that the word donor would include a man whose sperm is used to conceive a child through artificial insemination. And that assumption then drove its conclusion that section 742.14 applies in all paternity actions involving artificial insemination. As this court explained in cases such as Alachua County and Connage, a court must exhaust all textual and structural clues that bear on the meaning of disputed text. In this case, those clues compel the conclusion that the definition of donor, as used in section 742.14, does not extend beyond the context of assisted reproductive technology.
When you say extend beyond the context, I'm not sure I understand exactly what you mean. The word donor is not defined in the statute, right?
Correct.
So, I mean, standard operating procedure at that point is we seek its original public meaning at the time the statute was enacted, right?
That's the starting point, correct.
Okay, so, I mean, if we then do that, then I think any definition of donor that would be, you know, intuitive to an ordinary speaker of the English language would be someone who gives. A donor gives. A donor, therefore, alienates him or herself from the thing that he or she is giving, right? A donor is also, in the sort of original common usage of the term, different from a parent. We don't usually speak of parents as donors in common English. So help me out about the, I don't think I'm doing anything by I'm not broadening the definition of donor, quote unquote, beyond the statute. I'm just I'm trying to find the term's original public meaning and using it in the statute. How is that broader than the statute?
Well, the definition is not broader than the statute, but I think I agree with you that there is an intuitive use of the word donor that we often think about. But I think, as the court said in Connage,
it's not just intuition, right? There's the way this works is we agree what a word means, and for evidence of what that agreement is we look first to the statute to see if it's defined, if the legislature agreed to what the meaning of the word is. And if there isn't that, then we look to dictionaries and we look to usage and we look to, context. We look to the clues you were talking about. And then we do our best to come up with what would an ordinary speaker of the English language understand that word to mean. Help me understand how that's broadening the definition.
Well, I think that there are four particular clues that I think will compel the conclusion that what the legislator intended by the use of the word donor was a donor in the context of assisted reproductive technology. And I think that there's, so if I go through those four clues, the first clue is that, as the second district acknowledged or recognized, artificial insemination, such as the process that was used in this case, does not fit within the statutory definition of assisted reproductive technology. And that is because it doesn't involve the handling of eggs.
And there was, tell me if I'm wrong, but am I correct in understanding that there was already a statutory provision dealing with artificial insemination when this provision was adopted and when the provisions related to assisted reproductive technology were adopted?
Yes, Justice Kennedy. Section 742.011, subsection 1, is the balance that the legislature struck between the fundamental constitutional rights of a biological father on the one hand and the state's interest in protecting the rights of people who choose to have a child through artificial insemination. And the people that choose to do that, they can protect their rights by executing a written consent, which will make it an irrebuttable presumption that they are the parents of the child. So that had been in effect since 1973 and was in effect when the legislature enacted this other group of statutes in 1993. So that is a statute that protects those rights. And in DMT, the court acknowledged that the statute infringes on constitutional rights, and that therefore has to meet a strict scrutiny test. And in DMT, the court said, well, the compelling state interest was protecting the rights of parents who choose to utilize assisted reproductive technology to conceive a child.
Can you address the, it seems like your argument would be stronger if the exception didn't include the father with the pre-planned adoption agreement, because that doesn't necessarily, that when you look into the details of how that works, that they use the term, fertility technique, and they have a definition that could include the artificial reproductive technology, but it could include other types of things. And so one thing that I've been struggling with is that maybe the best way to understand this is that this use of donor is just in these two contexts, whether it's the surrogacy context that's with a gestational surrogate that's kind of outlined in the 93-237, the chapter of law that brought that into effect. And then you have the pre-planned adoption, which is another version of surrogacy where there's, written documentation, everybody knows what's going on, et cetera, et cetera. What do you think about that? But then I guess if you want to just kind of start with the issue of, doesn't the exception for the father in the pre-planned adoption, doesn't that kind of undermine the idea that it only applies in ART context?
No, it doesn't undermine it, Mr. Chief Justice, because the pre-planned adoption statute was in effect before the enactment of these statutes in 1993, and the pre-planned adoption agreement was the only way prior to 1993 for a couple to have a child using what is now defined as assisted reproductive technology. So the reason that that second exception in 742.14 exists is because if people do use a pre-planned adoption agreement, whether it's through the art or you're correct, it's conceivable that it can be beyond assisted reproductive technology, but the statute provides that if the adoption doesn't happen, if it's terminated or if the adoption contract is breached, the biological father remains the father, and the mother would be the gestational mother, who was in most cases a surrogate. So the reason for this other exception, which is dwarfed, in usage by the commissioning couple exception, is that there would have been the unintended consequence of interfering with that other statutory scheme that would keep the father involved in a pre-planned adoption agreement as the biological father in the event that the pre-planned adoption agreement didn't go as expected and culminate in an adoption. But so in every case, a pre-planned adoption agreement is going to include a volunteer mother who agrees to give up her child for adoption at the conclusion of the pregnancy or at the birth of the child.
In that case, in that context, she may also be the genetic mother of the child, whereas in ART, she's not.
Well, she may be, and in many cases, she may not be related to any party. She may be, because one of the main usages of pre-planned adoption agreement is somebody who gets pregnant, doesn't want, not with an agreement beforehand, but then wants to agree with another couple who want a child to adopt the baby. So it's not always used in artificial insemination.
Well, but no, I thought that it was all for fertility treatments. They enter into a pre-planned under the. It says in the pre-planned adoption arrangement, it shall include, but need not be limited to, the following terms. A, the volunteer mother agrees to become pregnant by the fertility technique specified in the agreement to bear the child and then to terminate her parental rights. So this isn't like, oh, I'm pregnant and I'm going to do it.
Well, it may include that. I think
well, not included. I mean, it's inherent in it. It's a necessary feature of it.
Well,
I guess. So,
but the point for this case is that there still would be no exception for a man who wants to become a father and have the mother be the gestating mother, as was this case. So in this case, the parties, their allegation, or my client saying she intended to become a parent with this man. Now, there would be no way to do that if the statute applies to artificial insemination, because regardless of what happens with a pre-planned adoption agreement, it will always include a mother who's giving her child up for adoption. So the situation that we have before us is artificial insemination, where a man provides semen to a woman who's going to be the mother and keep the child, will always lose his rights without exception.
Why does it always lose his rights if there's a separate statutory section on, establishing paternity? And then from there, like the trial court did in this case, the trial court went through testimony and said, I find this testimony credible, I find this testimony uncredible. For that reason, I find it's a donation in this case, and denies paternity. Conceivably, the trial court could, in this case, said, I find that testimony very credible. This was not a donation. He fully intended to be a parent the whole time. Why could that not have happened in this case?
Because of what this court said, Justice Sasso, in DMT, that we don't look at the intent of the parties to determine whether they're a donor or not. We only look to the mode of the conception. So that's why in DMT, the respondent was deemed a donor, albeit with an exception. But the trial court, there's no room for the trial court to take testimony to determine who is and who isn't a donor based on their intention.
So you think the trial court, and this isn't necessarily before us, but I understand that because you have that view of donor from DNT, that informs your interpretation of the statute. Do you think that the trial court in this case erred in taking testimony on it? That it should have just solely looked at the method of conception and then from there said that as a matter of law, anybody who provides, sperm through IUI or, anything like that is a donor, period?
Well, I don't think the court erred in taking testimony because I don't think that it should have applied 742.14. But what the court did wrong, and even the second district implicitly acknowledged the court did wrong, was what it did with its testimony is it, at the end of the case, it said, okay, I'm deciding which of you two, there are 3 people involved in the case, I'm deciding which of you two is the commissioning couple. And I don't think it's the mom and the biological dad. I think it's the mom and the wife. That is necessarily wrong because, as we know, the commissioning couple exception cannot apply in the context of assisted reproductive, other than in assisted reproductive technology. So
can I ask you a question? Sorry, go ahead.
So what the court failed to do is analyze the evidence based on the long-standing constitutional right of the father, which is an inchoate interest. But if the father...
It wasn't presented as a constitutional claim, though. You started your argument by saying this is a statutory interpretation claim, so I don't think it wasn't presented as a constitutional argument, right?
It was not. It's not a claim that statute is unconstitutional. To the contrary, I'm advocating for a construction that will protect it from being unconstitutional.
Can I ask you one question about you keep using the term assisted reproductive technology, which is defined in the statute and specifically refers to laboratory handling of human eggs or pre-embryos, does not talk about, donation of sperm, in contrast from 742.14. So how do we, it seems like your argument relies heavily on this definition of assisted reproductive technology being kind of read throughout the statutes or the various sections. So what do we do with the fact that the definition of that term specifically only refers to human eggs or pre-embryos?
Because the definition refers to the methods of the conception, and when it's the sort of conception where the woman whose eggs are being used is going to be different than the woman who carries the child, such that the eggs are going to be handled in a laboratory, then everybody, including the person who provides the sperm, in that case, is a donor, because they're a donor.
So that would not apply then to IUI, because there's no laboratory handling of the eggs in that case.
Right, it doesn't apply. It's not assisted reproductive technology.
So you think this statutory scheme applies only to IVF then? This is a IVF-specific statutory scheme, and there's no donation outside of IVF?
Except to the extent that there's any daylight between IVF and assisted reproductive technology, but generally there's
Well, that's
not.
defined. I mean, that's what I'm asking you. If assisted reproductive technology defines laboratory handling of human eggs or pre-embryos, that would limit this entire statutory scheme under your interpretation to IVF. I can't think of anything outside of.
Yes, it's limited to assisted reproductive technology, which is essentially IVF, because it's always going to involve. There are exceptions. There are other methods. There are other procedures where eggs would be handled in a laboratory, but generally, almost always, it's going to be one woman is donating her eggs, either donating to another woman or providing them to the surrogate. But importantly, she's a donor in both cases. But in one case, she's a member of the commissioning couple, and in one case, she's not, because intent is never considered. So to get back to your original question, that is what the trial court did wrong, and it's not a constitutional claim, but for any claim, anytime that a father comes to claim paternity and there's an intact marriage, the mother and another person, he has to prove the facts that would turn his own inchoate right into his constitutional right, and that is a very different standard than what the trial court did here and said, well, I'm going to pick 2 of the 3 of you to be part of the commissioning couple. But that's not the standard that should have been used. The standard that should have been used to determine whether Mr. Rivera is the father and has the rights of a father is whether he had demonstrated an intention to be the father through taking on responsibilities. That's the language that comes from opinions of this court in terms of how to rebut the presumption that normally exists when the mother is married to one person, but a man comes out and says, but I'm the father. There is a presumption that the spouse of the mother is a second parent, but it's rebuttable. And Mr. Rivera in this case was not given the opportunity to rebut it because the trial court didn't even consider that standard, but instead tried to decide which of the 2 people are going to fit commissioning couple, and there's no room for any commissioning couple in a procedure that does not constitute assisted reproductive technology.
Is it possible that this statute, rather than being focused necessarily on this kind of narrow definition of ART, that it's really that the scope of the rule applies only in the gestational surrogacy context? Because the changes that when in 93-237, in addition to kind of setting up the scheme with the commissioning couple and all that, it also amended 742.11 1 and 2 to kind of have these carve-outs for gestational surrogacy so that the husband of the surrogate wouldn't be under the normal presumption. You don't want him to be presumed to be the father of the, you know, of the ensuing child. I mean, so is it possible? Because, I mean, we're all sort of trying to figure this out in a textual sense. We don't want to just kind of say, oh, the consequences are bad, whatever. You know, so we're looking at this, we're trying to figure out the clues. I think maybe some of us have an intuition that the reasonable understanding of what the scope of the rule would be is not as broad as it may appear on its face if all you do is focus on the donor thing in isolation. And I'm wondering if the gestational surrogacy context, which could include commissioning couples and it could also include the pre-planned adoption, I'm wondering if that's the relevant scope for where you would apply the rule.
Yeah, Mr. Chief Justice, I think that's actually a more succinct way to say what I was saying, because to the extent that there's any daylight between a gestational surrogacy and assisted reproductive technology, and you're pointing out that there is some, I do agree that the statute would apply really to the context of gestational surrogacies, but still not in this case. But in almost all cases, a gestational surrogate is going to be somebody who gets pregnant with the eggs of another woman, so it's usually coterminous. But to the extent there is daylight, and I think there is the possibility for daylight in the definition that you read earlier, I think that it is fair to say that this is a statute that governs gestational surrogacies.
And can I ask you, I mean, one thing that could be also helpful is sort of the mischief issue. I think I read somewhere that the first gestational surrogacy happened in 1985. Obviously, in vitro fertilization was around much before that. Is there any kind of publicly available information that you could point us to that would maybe give us a sense of whether this statute was a response to the phenomenon of gestational surrogacy as opposed to sort of sneaking into, and I don't mean in some nefarious way, but it's a little bit of an elephant in a mouse hole in the sense that if you have something that overall appears to be mainly focused on gestational surrogacy, and then you slip in this provision that's going to swallow all this other stuff with artificial insemination and apply in all these, different contexts, everything from like an anonymous sperm bank type situation to, two people who sort of voluntarily are doing this, maybe even on their own, et cetera, et cetera. Is there anything objective out there that could give us a sense of sort of what it was that prompted the enactment of this law?
Yes, I think so. One thing we cited in our brief, one particular case, but as an example of cases, and I think it was in the 80s, and it was a case where it was another state where they used essentially the pre-planned adoption agreement, but there was a breach or a termination, and it led to a dispute as to who's the mother, the woman who is genetically related to the child because her eggs were used, or the woman who carried the child and delivered the child. And the court in that case, and that was a case out of state again in California, had to resort to the intentions of the parties, and it very specifically said it had to do that. And when this set of statutes in Florida was enacted in 1993, and this court has, explained in DMT that the very purpose of it was to avoid that very type of inquiry into the subjective intentions of the parties, because it set up a statutory scheme that says, hey, if every woman who delivers a child, that's the mother, unless you have this agreement that's set forth and described in section 725.15, where you have a commissioning couple on the one hand, and you have the mother who's...
Why would we look at that instead of, if we're looking for something objective, that there is, the Uniform Parentage Act and the model legislation that was passed that specifically identified this hole that these women who are becoming pregnant by donated sperm, who didn't want to go the very expensive IVF route and are using at-home methods, would have the same protection of the legislation that women who had the means to do IVF. And now we have at-home IUI kits and all that sort of thing, and that this statutory scheme was meant to capture that phenomena. And you see that reflected in the Oregon case that's cited in the briefs, the Texas case. Why is that not a better indication of kind of like the objective landscape that led to this legislative change?
Because the definition of reproductive technology or whatever definitions are in these other states is broader than the definition of assisted reproductive technology in the Florida statute. And as my dialogue with Justice Kennedy earlier revealed or underscored, we've already have a protection for artificial insemination. And the women in this case, if they wanted to protect themselves from any rights from the father, could have executed these consents, and under 742.011 subsection 1, they would unrebuttably be the parents. So the answer is that Florida shows a different statutory scheme than the model rules or these other states, and they very deliberately have one set of rules that governs assisted reproductive technology as defined, and then they also have a rule to protect the people who are trying to have a child through artificial insemination. And those two rules, if you apply 742.14 to artificial insemination, those two rules are in conflict, because on one hand, if the parents, parents can sign an agreement. If the parents don't sign an agreement, rather, like as in this case, and there's not an irrebuttable presumption that they're the parents, but yet Section 742.14 says it doesn't really matter if they signed it or not, because we're eliminating the rights of the source of the semen either way. So if 742.14 would apply to artificial insemination, it would essentially read out Section 742, subsection 1, as completely unnecessary, because why do we need that presumption to protect against claims of a man who provided the sperm if 742.14 is just going to say, well, that man has no rights automatically?
Well, and also, I mean, the public policy, I think that obviously there is some contemporary sense of people, people thinking about the interests of women who want to be to have children through artificial insemination. But if you look at the public policy of the state at the time and the statutes at the time, they're very concerned with the concept of a mother and father. I mean, even in the context of the adoptive arrangement, if the whole deal falls through, the commissioning or the intended father is on the hook for being responsible still, even if the adoption doesn't go through. You look at the fact that commissioning couples here have to be, again, in the language of 1993, man and woman, husband and wife, whatever. And I don't know that there's any evidence that the public policy in Florida was to, you've got the interest of the gestating mom, you've got the interest of the intended parents, you've got the interest of, potential donors, you've got the interest of the child. And it seems like if you apply the donor provision sort of in a blanket way, you're sort of creating, as a matter of law, this category of legally, fatherless children in a way that doesn't take into account any of the details of whatever may have been going on. That may be, if you have a regime that allows there to be fact-finding on what people's intentions were and all that, it may be that that's the correct outcome. But to sort of preempt that whole process and say, you are sort of legally fatherless because this person is a quote-unquote donor who had to relinquish rights, et cetera, like that would be totally inconsistent with the public policy of the state as far as I can tell.
Yeah, may I answer?
Yeah, go ahead.
I'm over the time, and I apologize for not asking you that before answering other questions when I wasn't over the time. But no, that is absolutely correct. And if this statute includes artificial insemination, such as it would eliminate the rights of the source of the semen in that case, without either of these exceptions, this will be the only way to, with state sanction, conceive a child that will only have one parent, because the pre-planned adoption agreement scenario, there's going to be a judge at the end of the day who decides who the parents are. So, and this particular statutory scheme that includes 742.14, this is going to end with a commissioning couple, as you say, two parents. So this would be the only way, if the second district is correct about how it interprets it, this would be the only way where the state is providing a way for people to have a child that automatically might only have one parent, because if
yeah, and it would happen in a context where there's no guarantee that there's any kind of informed consent or anything. I mean, the other thing that jumps out about this stuff is that in the context of the commissioning couple and then the adoption thing, there's like all kinds of belt and suspender safeguards to make sure that everybody involved in the transaction understands what's going on. And then if you just apply the donor across the board, outside of situations where there's going to be, written contracts and all that, like these rights are going out the window, and no one, there's no guarantee that anybody would have any clue about that. Which, again, maybe policy-wise, that's what people would want, but that doesn't seem like that would be a reasonable inference about what the legislature was doing, given all this other stuff.
I agree, and in this case, the trial court literally was interpreting text messages between the three people to determine, whether the intent was for Mr. Rivero to give up his rights or not. But that's not the way that we waive constitutional rights via text messages. that aren't clear. I mean,
Okay, you can have a couple of seconds to wrap up.
Thank you, Your Honor. So I would ask, I assume that I've eaten through all my rebuttal.
No, you can have 3 minutes for rebuttal, and obviously you can have as much time as you need.
Thank you. So I think the only way to read this statute in a way that is consistent with the Constitution, which the court is required to do, notwithstanding that it's not a constitutional claim.
Well, we're required to adopt reasonable readings that would avoid constitutional problems if the reasonable reading is available.
And I think we've discussed alternate readings this morning, and the reading that would be the broadest reading, that would sort of be the elephant in the mouse hole, as you described it, would enable, would take away the right of fathers to prove that they intended to be the fathers, which goes against very fundamental law regarding parentage. So,
okay, thank you. Thank you.
Can I ask how much time I'd have for rebuttal?
3 minutes. 3 minutes.
Thank you.
Good morning, Mr. Chief Justice, members of the court. May it please the court, I'm attorney Robert Ongstadt from Tampa Divorce, and I represent the respondent, Jennifer Salas. We're here today about Florida Statute 742.14, specifically this following certified question from the Second District Court of Appeal. The question is whether Section 742.14 applies to paternity actions only when the child was born as a result of assisted reproductive technology. On behalf of the respondent, I ask you to find no, and that it applies to any donor. I'm going to go briefly through the history of the case. So this statute was established along with the other related statutes 32 years ago in 1993 and has not been changed to date. We had 742.11, which talked about the artificial or in vitro insemination and about the irrebuttable nature. And it shows to prove that the legislator's intent was to protect parents from the interference of third-party donors into their custodial rights.
Well, but it also began with the gestational. I mean, the one common denominator. There is some overlap with that, but I mean, one common denominator, if you look at the changes they made, is to specifically address the gestational surrogacy context.
Yes, Your Honor, and I agree that's for 742.11 that specifically does that. With 742.13, that's where we get our definitions from, which includes an assisted reproductive technology definition. We have the commissioning couple definition, and we have sperm. In fact, the word sperm is mentioned 6 times in 742.13, but it is not mentioned under the definition of assisted reproductive technology, and courts have consistently and repeatedly held that donating sperm is not assisted reproductive technology. Since then, the case...
But assisted reproductive technology is going to involve sperm.
It does, Your Honor, but I'm more referring to the relative factors of this case, the at-home, do-it-yourself insemination.
I'm just saying, though, but I mean, it's hard. We've got the definitions. This is like a complicated. I mean, I don't need to tell you. This is like a almost incomprehensible sort of web of things that are all kind of interconnected.
It is, Your Honor.
So, if you're going to have artificial reproductive technology, you're going to need a sperm donor, and so it's not to say that you're going to have, these line drawings of, donors and what their rights are, and that because it mentions sperm, that takes it out of the context of ART. That doesn't make any sense. It might, but it won't. It wouldn't for that reason.
Understood, Your Honor. Well, it does specify that's the laboratory handling of pre-embryos, and then, of course, zygotes, and then gametes. So, yes, things that have already had sperm applied to them. So I do agree with the court on that. The district courts of appeal have repeatedly and consistently held from 1993 all the way up until 2022 the interpretation that we are asking you to adopt today, and the trial court and second DCA did in this case. In 1999, LAL versus DAL was before the second district court of appeal, and again they found that the courts first had to look at 742.14, which again was the same as it is now. And then 2002, Lamari Tata v. Lucas, the second district again found that because Mr. Lucas was a donor, he had no rights unless he was part of the pre-planned commissioning couple or a pre-planned adoption agreement.
Can I ask a question?
Of course.
Under your kind of reading of the statute, if, let's say we have two individuals, only two involved, and there's a at-home artificial insemination used, and at the hospital, birth certificate people come around, both parents are there, both people are there, they both do the affidavit, they establish, they both sign, that establishes paternity.
It does.
Legally, correct?
Yes, Your Honor.
Which trumps? Has the biological father waived? He has no rights that can never be asserted because he would be a donor under your definition. Or does that act of filling out the affidavit and being on the birth certificate reestablish his rights?
That's an interesting scenario because under 742.10, once he's on there and 60 days has passed and no one's objected, he's the legal father. So that would give a path for someone in, say, Mr. Rivera's situation, potentially.
So a donor doesn't forever relinquish rights under your theory?
It doesn't. What's interesting, too, is if we look at this court's ruling in DMT, that was a biological egg placed into another woman, and then that child was born. And in that case, the court, again, protecting the role of the family and that family's right to raise a child free from interference of a donor third party, said, no, she's not a donor, she's a parent. And because she's a parent, it would apply, but again, we have a parent situation. So in that situation where you have a clearly intended parent, I think that would be different. But of course, the facts at issue today, we do have a donation made to an intact couple.
So the case from the 5th district,
yes, sir.
That involved friends who seemed to intend, the child was 7, the person had been involved in the child's life I was referred to as dad for 7 years. Would you consider that a completely different situation than what you have here?
I would apply the statute the same way that Justice Sasso did in her dissent.
So he would have no rights?
As the dissent in that case says, unfortunately, we apply the statute as written, and sometimes that leads to unfortunate.
Well, let me ask you about that situation because so the dissent in that case started out by highlighting the fact that there's no transcript, and so this goes to the DMT issue. The trial court in this case took testimony on the facts surrounding the conception. I think opposing counsel has indicated that he believes that because of this court's opinion in DMT, that kind of factual analysis when it comes to donation is wrong. That it's just kind of, you look at the method of donation, and if you've done that, you're a donor, period, end of story. Do you think that DMT, if that's correct, if DMT's assessment of donor as well, that courts are legally prohibited from looking at intent or anything like that when it comes to donation, do you think that is consistent with the rest of the statutory scheme?
I do, and that's because Lamaritata v. Lucas from the Second says that to it as well. So it's very much, once you're a donor, unless you're one of those two exceptions, you're out, which is what you ultimately, Justice Sasso wrote in the denial, which is we look at the plain meaning before we look at any outside clues, and that's the.
And so just to follow up on what the Chief asked earlier to the other party, if you had two people who made no agreement and they have a child through a more traditional sense, not marrying, to give up those rights require mountains of paperwork. I think this is still 14-point bolded font on all the consent forms, numerous notaries, just a huge hurdles to jump through in order to waive those rights. But in this case, where you might have two people who make a decision to have a child together, but just happen to use that technique, this trumps, kind of that whole concept of waiver of parental rights. This is kind of one sentence.
Yes, Justice Christians. I think it goes back to the the legislator's intent to protect the intact family. So when you have two people,
Well, that's not it's two people. Man and right, let's say it's a man and a woman, like in the 5th DCA case where you had two friends.
correct. Well, in the 5th DCA, that's the at-home and do-it-yourself insemination. I just want to clarify your example. If you're referring to at-home insemination, or
Well, I would just say, you have in the case where you don't use that, and you might have people not even intending to be parents.
Right.
You've got hurdles and hurdles to waive your parental rights as the father. But what you're saying is, even if there was an intent to be parents, that you just happen to use that technique in sort of an obscure line of a difficult statute, all of that goes away. They've waived all parental rights.
well, I believe yes, that's correct. But the difference when people do it the old-fashioned way, there's a whole separate set of case law about that, and a lot of that case law centers around a child's right to be supported financially. So when we have this donors section competing with because I think you're referring to a termination of parental rights case or child support obligations, because yes, as a family law practitioner, people will come to me and say, well, I just want to sign away my rights. I'm like, not so fast. You made a kid, they have to eat, they have to go to school, they have supplies. And that obligation is extraordinarily difficult to get out of.
Yeah, so why would a rational legislature treat, the old-fashioned type of reproduction between two unmarried people differently from this? In the one case, it's, the sperm donor male is, on the hook, for all that stuff. And then here, not only are they not on the hook, but their whatever right, quote unquote, rights they would have are gone, whatever obligations they have are gone. I mean, and I understand that, legislatures sometimes make bad rules, but if there's a way that's textually permissible to read the rule that wouldn't do something that's so kind of counterintuitive and contrary to public policy, why wouldn't we do that?
Yes, Your Honor. And the legislator has made changes. I mean, we can just look at the alimony statute rewrite in 2023. So, typically...
Well, let's talk about 1993. The mind, if there is such a thing as the mind of the legislature in 1993.
Well, the mind of a legislator is hundreds of people over multiple different sessions. And again, it's still today as well. It's not just 1993.
No, but we have to figure out what was the rule that was put in place in 1993, and until changed, that's the rule that we're governed by.
That any donor of sperm is out unless they meet the two exceptions.
But not out forever.
Well, out unless they meet the two exceptions, or the legislator potentially changes the rules as well.
Or they establish, or they establish paternity through the paternity statute.
Right, or they establish paternity through 742.10.
Or some other written agreement.
Well, but I don't understand that, because it says shall relinquish.
Right. I mean, you can't.
It sounds like shall relinquish. It's gone. Ain't coming back.
That's what it says, Your Honor. Yes, I agree.
And so, if you're gonna be literalistic about this, you're gonna be tied to that sort of thing. Isn't that correct?
That one's more challenging because with the facts of this case,
I thought it would be.
We have a married couple and we have two people on a birth certificate and one trying to assert. Under the other example, it would be there's a single parent on a birth certificate and there's a statutory mechanism for a person to add themselves and for the other person to object within 60 days. That's 742.10.
Can I ask the question this way? In the context of the statute, are the terms donor and parent mutually exclusive? That is, if I'm a donor, I am not a parent, and if I'm a parent, I may have contributed genetic material, but I'm not a donor.
That's a hard one, and that's one actually the second district in this case referenced when referring to DMT, because they said in that case the party could be theoretically both a parent and a donor. I would certainly answer your question directly, potentially yes, but potentially no. With the facts that we have today, the answer would, for the underlying case, it would be a no, because again, it's a donation made to an intact couple.
Well, I mean, we know from the exceptions that the donor and the intended father in the pre-planned adoption agreement can be the same person. Otherwise, there wouldn't. I mean, that's like an explicit exception. But all these problems about, that you're, that are not, it's not your fault, but I mean, all these like tough hypotheticals, if you only apply this rule in the context of gestational surrogacy and the pre-planned adoptions, you have a comprehensive statutory scheme that's designed to tell you who the parents are, who's going to, it assumes that you're going to have, a father and a mother. Again, 1993, there haven't been all the tweaks to account for, evolving mores, whatever. You've got a father and a mother, who's going to, be on the birth certificate initially, the process for then getting it, trued up. The old birth certificate becomes a confidential sealed thing. Like this whole thing, it kind of makes sense and fits together, and it doesn't have all these kind of, trying to have a rule that might make sense for an anonymous like sperm donor at a sperm bank, but that really doesn't make any sense when you're talking about these kind of ongoing relationships and whatever. So why isn't that the more reasonable and sensible way to understand what this is all doing, is to apply it in the context where the legislature clearly kind of tried to put together all the pieces of the jigsaw puzzle in a way that makes sense?
Yes, Your Honor. Well, I would point out that this statute is unchanged since '93, and the legislator has been in sessions many times. This underlying case got a lot of attention. The Enriquez v. Velazquez back in 2002 got significant attention. There was an amicus brief submitted by the Florida Bar Family Law Section in Enriquez Velazquez 3 years ago, and they've also submitted one today. Another known function of the Family Law Section is to propose legislation, which we saw effectively took place in 2023 with the revision of the alimony statute, with the revision of modifications. So for us to infer a broader meaning to the legislator when the legislator itself hasn't done it, in essence, I'm asking the court to apply the statute as written and to let the other branch of government, the legislator.
I mean, I'm not trying to be critical, but the whole apply it as written thing, that's what this whole thing is about. So obviously, as it's written, it's in context, it's part of this kind of seamless web of stuff. So I don't think that it's really helpful to just say, quote unquote, apply it as written, when the whole point is, what is the legal significance of all of these writings looked at together?
Understood, Your Honor. And up until Enriquez v. Velazquez, courts have unanimously ruled in the way that I'm asking you to rule today, that any donor means any donor, and to just apply that strict constructionist interpretation of the statute. And only if it's unclear in 742.14 to go outside to the other sections of 742. And as Justice Assa said in her dissent, it's very clear, and that's the end of the inquiry. Are there any further questions? All right, perfect. Then I will ask the court to affirm the second DCA's ruling and to answer the question of whether, just affirm the second DCA. Thank you.
Thank you very much.
Thank you. I wanted to first answer Justice Correal's question, whether donor and parent are mutually exclusive. And they're not mutually exclusive, because, but that's because of the exceptions that are provided for in the statute. And that's exactly why the exceptions are provided for, because as the court in DMT said, you're a donor if you are one of the contributors biologically, which is inconsistent with our intuitive understanding of the word donor, because you don't think of a donor as somebody who is giving something, using his sperm, giving it so that a child can be created for him.
It's not just intuition, though. That is what the word means, and this is part of the dance we did in DMT about intention. To say that we don't consider intention, like a donor is defined by donative intent. It's like saying the word swimmer, but we don't look to see if the person is swimming, right? Like obviously we have to, if someone is a donor, it's because they are engaged in the act of giving. We agree about that?
I agree that that's the general definition of donor.
Okay, so it's not a matter of intuition. That is the commonly used, that is, we speakers of this language agree that the word donor includes the act of giving. Fair?
Yes, that is what we generally
Okay,
understand.
it's not a defined term in the statute. We look to the common usage of the word.
But we also look to what this court said in DMT, and what it said was that we don't look at intent. And if we did look at intent, then these statutory exceptions would be irrelevant.
We don't look at the subjective intent about like the going forward, the purpose of the donation. So far, so good. But we can't read that to mean that we don't, like, we erase donative intent. Again, going back to my swimming thing, that'd be like saying, okay, we're looking at the word swimmer, but we're not going to look at what they're actually doing with their arms and feet. Of course, we look, I mean, if we're going to identify someone as a swimmer, we're going to see if they're swimming. That's not about intent. That's not about that's not where they're swimming to, but it is looking at the definition of the word.
The reason we say subjective intent, and we're not looking at subjective intent, is because the legislature demanded that if you're going to have an arrangement and you're going to say that this woman that had a baby is having the baby of ours, that you need to have an agreement, and the agreement would define you to be the commissioning couple. So it does look at intent, it looks at objective intent, but the only objective intent is going to be found in an agreement that complies with section 724.15. I see that.
Did you have any more questions?
I'm good.
I see that I'm out of time, and I would just ask the court to.
You'll be back. I think you're coming back, right?
I'd ask the court to quash the second district's opinion, to vacate the judgment, and to remand to the trial court for a trial consistent with the rights of the father to establish his rights. Thank you.
Okay, thank you. The court will be in recess for 10 minutes.
All rise.
Got some stuff in it. Well, I was saying, not somebody who's I mean, I assume I have those. I should.
All rise. Supreme Court of Florida is now in session. Please be seated.
Okay, now we'll do Rivera versus Salas, number 2024-1190.
Thank you, Chief Justice. May it please the court. My name is Mark Neumeier. I represent the petitioner, Mr. Rivera, the biological father of the child at issue in this
Could you
case.
speak up a little bit? I'm having trouble.
Yeah, I'm sorry. I'm always soft-spoken as well. Mark Neumeier, representing the biological father in this case. Since we're continuing on from the previous argument, I did want to make a few points. First, of course, it is the same issue as just argued. Justice Sasso there was an indication that perhaps I misunderstood, but you thought that the trial court had made findings that this father was not involved and so forth. But as we indicated in the brief, the only findings that the trial court made in the order under appeal dealing with the credibility of the parties is specifically on the issue of whether they were commissioning couples. The court should have, under the proper evaluation that we believe was proper under Prevet, looked at whether the father had manifested a continuing concern over the child's welfare and had met that burden by clear and convincing evidence. The problem is that because the court got onto this 742.14 analysis, they never got there. He made no findings. If he had made findings under the proper standard, then we wouldn't be here because there would be an alternate sustainable basis for the decision that the court did. And I also want to point out, when we've been talking about the alternatives of perhaps later bringing, signing a birth certificate and so forth, this case did not just deny the petition, it dismissed it because under 742.14, the trial court found that my client had no standing to even be there in the first place. So this is not a situation where it's easy to remedy what we believe is the incorrect application of this statute to cases outside of the assisted reproductive technology statute. In DMT, this court specifically wrote in the opinion, furthermore, we necessarily must read sections 742.13 and 742.14 together. So this court has actually already looked at the fact that this is a coherent statutory scheme. It's tied together. Yes, there's no definition of donor in 742.14, but if you look at the definitional section, it specifies which of the subsections of the statute it applies to. So if you look in the definitional statute, it kind of ties it together that these 5 subsections are the assisted reproductive technology statute. Now, keeping that in mind, it doesn't help you a lot when you go looking in 742.13 for a definition of donors. It's just not there. So perhaps we infer, but if you're reading those two in parametri, again, we feel that donor as used in 742.14 necessarily is restricted to those situations involving assisted reproductive technology. My brief, unlike counsel who focused more on the statutory history, statutory interpretation, mine more went into, as a practitioner in family law, the unintended consequences of the application of 742.14 to cases outside of...
Let me ask you this. The legislature could have cabined the effectiveness of this statute more affirmatively, right?
Yes, both ways, Your Honor.
We don't see any legislative choice saying the provisions of this section shall only apply to assisted reproductive technologies, period, full stop. We don't see that choice either, right?
Yes, and they could not only have put that in at the beginning, but with these other cases, they could have gone in and put it in afterwards to provide more of a clarification.
Absent that affirmative choice by the legislature, aren't we to presume that the law is the law?
The problem is that the legislature has dumped this question on this court.
Well, I mean, I'm not sure I agree that when the legislature acts in a way and says no more, that it's dumped anything. It's just legislated. And I guess my question is, why aren't we to assume that the legislature had the choice to make clear what you're arguing for, didn't, use the common, ordinary understanding of donor, and dropped Mike, you know?
Yes, because applying it that way leads to irrational, contrary, and conflicting results, as counsel indicated.
Possibly conflicting results, but yes. What's irrational? Help me understand what is the irrational result of giving it that effect?
Irrational, Your Honor, is if 742.14 is untethered and donor has its common meaning, that means that not merely pregnancies resulting from artificial insemination would be covered, but all impregnations. Where does it say not the old-fashioned way? Where does it say non-sexual?
It says donor.
It says donor.
Look, I am willing to bet that in a whether it's within a marital union or a non-marital union, you know, whether it's by the old-fashioned way or at-home technology or whatever, folks who have no donative intent are not donors. We don't refer in normal parlance to a couple getting together and deciding to have a child as donors. In a very technical sense, they're each giving genetic material, and the legislature could have chosen to define that. Instead, they said donor in its commonly understood meaning, because people understand that when they get together and have a baby, they're not being donors.
The problem, again, Your Honor, is that there is already law that covers what happens with artificial insemination. There is already law that deals with what happens with pregnancies out of wedlock. There is already statutes that deal with this, and giving it that interpretation leaves it open for an interpretation, an application as here, which would have constitutional violations as a potential outcome. That is,
hard to imagine an application of the law that doesn't have any law constitutional implications as a potential outcome. I mean,
I would disagree, Your Honor. This is one of the highest
we're here all day on all sorts of stuff. I mean,
yeah, this is one of the most fundamental of the constitutional rights. This is not, can I write something on a postcard and somebody takes umbrage? Is it slander? Is it, is it an invitation to run fire because I said something that was wrong? This is a case where a person who may or may not be a parent of a child is barred forever, both from any rights to enjoy the upbringing of the child, the company of the child, and is stripped of any obligation to provide child support.
Doesn't the statutory scheme reflect a series of legislative choices about how someone in your client's position can avoid this horrible situation?
It doesn't, Your Honor, because if 742.14 doesn't apply, he doesn't have to do anything. He just goes there, he gives his material, and the law talks about what you do if you get somebody pregnant prior to them getting married, how you can go in under Privet, what you have to do in order to prove that. For instance, there's also in this statute, and there has been for quite a while, DNA testing. If we say 742.14 applies to all pregnancies or even all artificial insemination.
There's no court that's ever said it applies to all pregnancies, though. Has there been a court that has said that it's applied to all pregnancies?
That's true.
Correct. And when we look at 742.12, it talks about the requisite sexual contact and that sort of thing. That would seem to define the old-fashioned way, as the second DCA or fourth DCA referred to it. And when you look at the donation statute, it refers to artificial insemination. And I think every court that's addressed it has cabined it to the artificial insemination. So I think you're advocating a position that if this court reads it that way, that it would include every pregnancy that's ever happened. And I don't see any evidence textually or from the way any court has interpreted it since the statute has been in effect that would lead us to that conclusion.
Your Honor, what my position would be is that if you follow the statute the way that I'm advocating, there's going to be an objective third party available. Like in many of these other cases of other states, there has to be a doctor involved. There has to be at each step an objective third party who will be involved, able to give an objective evidence. Yes, this semen was put into this egg or whatever it is, and at each step of the process would therefore have an opportunity to provide information needed for an informed consent. By the way, you understand what this means. I'm taking your egg out. By the way, here's some forms to sign, including potentially what we understand the legal obligations are going to be. The problem is when you talk about artificial insemination and the old-fashioned way, does that mean digital penetration?
Let's take the old-fashioned stuff off the table, okay?
All right,
I think though that would be helpful for us to hear you elaborate on is, I think one of the things that's emerged from the discussion today is that if you literally understand the relinquishment of the rights of the donor, understanding it, the way the other side wants to, that some of these things that might appear to be workarounds, having side agreements or whatever, it's possible that they're not really legally available because of the shall relinquish rights and obligations language. So could you elaborate on that?
I think that is definitely a problem. As using the second DCA's interpretation, it is unclear whether there can be a later workaround, either by way of signing an acknowledgement of birth and getting a birth certificate, potentially marrying that person who had the child, because then you would get under the putative father manner of obtaining birth. But the problem is there may be available ways to do it, but if you're not able to do any of those, if you have every intention of getting together, living together, having this child, and then a week before the baby is born, you have a big fight and you're separated, you're not on the birth certificate, and it just happened that because of the reasons set forth in counsel's initial brief, allergies to proteins in semen and so forth, so there may be reasons why you would have artificial insemination even though you're fully intending to do this the old-fashioned way. It's just that you can't get pregnant the old-fashioned way, so you have to use these other things. If we apply this statute the way the second DCA says, that's a bar. That is a bar, and that is a very, you can almost not understand, other than losing your life, losing your children, that's a very severe sanction to be governed.
And it's also, the issue too is from the child's perspective, which obviously seems to have been very much a concern of the legislature if you look at all the different touch points for this stuff.
Yes.
It's not just about the two, adults, or how, obviously there's all kinds of, one of the things with this whole context is that there's like so many permutations of the different cast of characters that can be involved with this.
Yes, and I would suggest that the Privet is this court's best shot at, and a very useful one as well. Clear and convincing evidence, a manifest involvement in the child's welfare and benefit, a little bit further afield, but doing a best interest analysis, the capacity and disposition to provide for the child's emotional, physical, financial
Are you asking us to write that into the statute?
So that's just...
Sorry, go ahead.
So you're just saying by finding this wasn't applied, you just go to the traditional paternity process.
You do, but again, otherwise you don't get in the courthouse door if your rights are stripped because of the application 742.14. You don't get to have a best interest determination because you don't get into court. You don't have the right to take action to try and get...
Well, you don't get an opportunity to talk about whether the intent was donative or not, correct?
That we're getting again into, but yes.
Well, if you can't get in the door, you can't talk about anything.
That was a softball. The answer is yes.
I'm sorry I did not make that clear. But
yes,
forgive me.
Again, it is a very strict penalty. It is a very strict penalty, not just to the parent, but also to the child. You don't inherit. You don't get child support for life. Certainly not giving child support to kids is not one of the policies behind this statute, 742, completely. So interpreting it in a way that strips the child of not just the social interactions with one parent, but the right to financial contribution. Suppose this guy is a horrible parent. There can still be child support, but not when 742.14 is applied in the way that the second DCA is doing it.
So you're into your rebuttal. You're welcome to keep going, but we're going to stay on time for this one.
Thank you, Your Honor. If I could have just a second. Just want to make sure I've hit all my points. In conclusion, reserving my time, whatever is left for rebuttal, this is once again a situation where law is chasing science, and we're trying to find ways to make this all make sense morally, socially, policy-wise, and we're chasing culture as well, as much as we don't want to have to do that. We believe that the proper interpretation of 742.14 is that it be restricted to the context of assisted reproductive technology, which involves the laboratory handling of human ova or pre-embryos. That is what makes the most sense, and that is what keeps us both from potentially stripping rights from kids and parents, and it prevents other aspects of the statute from being contravened by such an application. Thank you.
Thanks.
Good morning, Chief Justice. May it please the court. I'm attorney Robert Oxtott, and I still represent the respondent, Jennifer Salas, from Tampa, Florida. I'm going to pick up where he left off a little bit, because I think it's important that we remember the facts of the case that's before the court. In fact, these facts are different from DMT in a way that the second DCA below said it could make a different ruling because we had different set of facts. The facts in this case is we have a committed couple in a relationship, both women, that Mr. Rivera goes to their home. And by the way, he's the third person they asked and the second person that attempted this procedure. So this is not a situation of stripping away some unknown rights. He made his donation and left that with Salas, the respondent. He never even saw Brito that day. That Brito got pregnant, that the parties got married, that the child was covered by insurance from Salas, and then the child was born during an intact marriage. So when Rivera came along and filed when there was marital strife between Brito and Salas, so Rivera and Brito filed for paternity, and subsequently that was set aside once Salas got involved and then upheld again and again. But I want to touch on the Uniform Parentage Act that was addressed a little earlier during my last presentation, because I think that's important, because if this court expands the definition of 742.14 or expands by adding the words that the Fifth suggests, that it applies only to assisted reproductive technology, the assisted reproductive technology statute or definition itself requires a laboratory setting. And that would go against what this court has been trying to do. For example, the Uniform Parentage Act was refined to remove the licensed physician requirement. Before, you only had protections if it was performed by a licensed physician. And it was removed, saying, well, it's not fair, equal protection to people that can't afford a licensed physician, 15, 20, 30,000, whatever IVF or using a physician cost. And those people should still have the right to have a family free from the interference of a third party, whether it's same-sex like our parties here, whether it's a traditional opposite-sex husband and wife that just can't, for some whatever reason, have children there, just to not have the interference of this third-party donor and not have the roadblock of having to have the money for a laboratory setting, which if we apply what the Fifth District did, we're adding only through assisted reproductive technology.
I think, though, that, you're saying expanding. I think that if the contrary position to yours were to prevail, it would contract the scope of this rule, and it would essentially allow other sources of law, contract, the generic paternity stuff, whatever, that would sort of fill in. And in a way, that those other sources of law are much more nimble and much more able to be adapted to all the different kind of fact patterns. I mean, I think one of the things that people are struggling with is that this rule kind of fits in the context of these gestational surrogacy arrangements where, you know, everybody knows that there are certain parties who are kind of by definition, it's baked into the arrangement that they're intended to go away, et cetera. And that rule, and maybe the correct statutory interpretation answer is that the legislature just enacted an overbroad rule, but maybe they actually didn't. Maybe they have a coherent scheme, and that the proper understanding is to let the other sources of law do the work the way they can, and only use this rule in the context where it actually makes sense.
I would agree if the rule itself weren't so clear on its face with the word any, as Justice Sassa said in her dissent, where if the statute is clear on its face, then the inquiry stops. That's the end of our session, or that's the end of our, is what I believe, Chief Justice, you're questioning about is, well, shouldn't we look in the context? Shouldn't we look at the overall picture? Or maybe the legislator can revise the paternity statute, because that's right, Privet, there is a way. There's other means to establish best interests of the child. I don't know of any that involve 3 parents, which would be the alleged situation if that side prevails, but not technically.
But the point is that the effect of this rule, because it's so blunt, is that it cuts off any inquiry into, just because you can get in the door doesn't mean that you're ever going to get any rights or that you're going to be on the hook for anything. It just means that you get the opportunity to have all of these things be relevant as they are or aren't relevant under these other sources of law. I mean, so it's not as if the court were to kind of contract the scope of this rule, it doesn't mean that it's imposing any sort of, similarly kind of blunt rule on these other contexts. It just means that there's other sources of authority that are going to fill in the gaps.
Potentially, Your Honor, but to do that, the court would have to add words to a statute that the legislator hasn't done in 32 years. And there's also different, and the paternity statute, otherwise, it's not set up for 3 parents. There's no, Supreme Court parenting plan, there's only 2 parents.
Well, but that may mean that in this context, particular person loses based on all the other things floating around. But that's not, what's at stake in this case here today is this broader or narrower rule, however you want to frame it, that's going to have implications well beyond the context of this particular case and the particular facts of this case. Isn't that right?
It is, Your Honor. It is, Your Honor. And again, it's more of, again, I defer to the dissent in the Enriquez, which I also point out that the majority in Enriquez did not certify conflict with AAB versus BOC, even though AAB versus BOC applied it's the almost identical facts as the court in Salas said to here, and there was not conflict certified. I do agree with the dissent that conflict should have been certified, but again, it just shows that the application of law, if we take this, the law is written as is and apply that strict constructionist, then yes, under 740.
So under your reading, what Justice Coriel was referring to as the intent of being a donor, that wouldn't matter to you at all either. So it is the only thing that causes this to be in place is the fact that genetic material was transferred in a fashion using, an at-home kit. That's the only fact that makes a person a donor and subject to this. So that's it.
Kind of, yes. So yes, the at-home do-it-yourself insemination, as Lamari Tata Lucas said in 2002, and has been held since then, AAB versus BOC. So yes, subjective intent of the donor themselves is not.
Well, not even subjective. I'm just saying no other fact matters. No other relationship of the parties, how many parties are involved, if those people were in a relationship, if they weren't in a relationship, absolutely all of that is off the table. The only thing that happens that pulls this entire provision into play is that genetic material was transferred using an at-home kit. That's the only fact.
Yes, Your Honor, unless they have a pre-planned adoption agreement or are
which couples do all the time on their own.
Right. Understood, Your Honor. Or a member of a commissioning couple. And that's what's interesting about what the trial court did in this case, or actually what Lamaritata did in the second DCA, was they said that to be a member of a commissioning couple, you have to at least be some sort of rubric of a couple. So that's where your question would come in. If it's a couple that does this, well, that's a rubric of a couple, therefore it could be a commissioning couple. But if it's...
But not a commissioning couple according to the definition of the statute.
They are definitely not for this
So
case.
they would be out, like they wouldn't even be, that wouldn't be an exception because they're not a commissioning couple under the definition.
Correct.
So literally a couple who uses this, if they are not married, that male has zero rights.
Yes, under the statute as it's written today, and I would ask the court to apply it as written. And again, and I do realize that could be a harsh outcome under the Enriquez facts. Not as harsh for what we have today, where we had the committed couple that used a third party, but yes, in the Enriquez facts where you had two friends that said, let's get together and have a kid, and then one friend is like, you know what, I changed my mind, I don't want to see you anymore. I understand, and
of course the irony in that case is they both agreed about how it all should go, and then some circuit judge came in and disrupted what they wanted to do without anybody asking them to.
Yes, Your Honor. The sua sponte nature of the trial court was very...
Now again, that wasn't
right.
That wasn't really even argued in the district court, so that's not the district court's fault. But what a travesty!
I agree, Your Honor. But yes, in Enriquez, it was two parties. They agreed. They filed paternity together, and then the judge at the trial level, sua sponte, applied the statute and said, "We can't do this. Goodbye." And that is an unfortunate outcome. But again, unfortunately, the role of the courts is not to, even when there's a bad outcome, unfortunately, we must apply, not unfortunately, we must apply the law. So I have taken up enough time. I appreciate the opportunity to be here before the court. It's been an absolute honor, and I will yield the remainder of my time. Thank you.
Thank you very much.
May it please the court. My only point of response would be the UPA. That does contain separate provisions, I believe, for artificial insemination and assisted reproductive technology. So pointing out that the artificial insemination provisions have certain, the relaxation of the requirement of having a licensed physician, that is different than taking an assisted reproductive technology provision and applying it across genres, if you will, to artificial insemination. Otherwise, unless there's any other questions by the court, that's all.
Why do you think when in 93-237, when the legislature was making the changes to 742.11, why did they create this whole new subsection 2 on donated eggs or pre-embryos rather than just add those words into what's now sub 1 but before was the whole thing? Like, why does the legislature seem to make a distinction from I don't want to assume anything, but they treat artificial or in vitro insemination in one section, and then they have donated eggs and pre-embryos in the other section, even though the substantive rules appear to be the same.
I apologize, Your Honor, I don't know. I don't know why they made that distinction other than what I would speculate.
Well, I mean, I'm just wondering because it obviously raises the question of whether there's some, it's kind of in line with what your argument is, that there's this different treatment for the ART from artificial insemination, which obviously occurs in myriad kind of different sort of factual permutations, whereas ART, yes, because of the complexity of it and everything, it's much narrower.
Yes. That would, I believe, be the reason why, because it is more complicated, and there are, again, if they're talking about those kind of donations involving the maternal side of it, there are going to be, objective third parties and the potential for some informed consent there.
Okay, you got 15 seconds.
We would ask that the court reverse the ruling below by the second DCA. We would ask that the court specify that the forfeiture requirements of 742.14 only apply within the context of assisted reproductive technology as set forth in the comprehensive statutory scheme, and that the case be sent back down so that my client can attempt to prove under Privet that he has some rights relating to this child. Thank you.
Thank you very much. We're adjourned.
All rise.